Hi, I'm attorney Gregory Dell here with attorney Rachel Alters, and we're going to discuss some tips for how to prevent a disability insurance denial when your definition of disability changes from an own occupation to an any occupation definition of disability. So I think the first thing, Rachel, is to make sure people first understand what is the own occupation definition of disability, and then also discuss what is the any occupation definition of disability commonly found in most long-term disability policies.
Sure. And these definitions change mostly in a group policy, which is governed by ERISA. So most of these policies will say that you can be disabled under the terms of the policy for the first 24 months if you cannot perform the material substantial duties of your own occupation, which is usually as it's defined in the national economy. So what that means is it's not technically how your occupation is defined at your place of work. It is not the specific job duties that your typical employer, your specific employer requires you to perform, but it's how the Department of Occupational Titles, or ONET, defines your occupation. So that occupation would, so let's say it's an office manager. So they will look up office manager on the Department of Occupational Titles. There'll be a list of duties, and that's what the insurance carrier will go by. So for the first 24 months of your policy, and some policies actually only will have a 12-month own occupation, and that's a very short own occupation definition. Most of them, I would say about 85% of them, are a 24-month own occupation. After the 24 months, so let's assume that the claimant gets approved under the own occupation definition and the carrier agrees that they're not able to perform the material substantial duties of their own job as it's defined in the national economy. After 24 months, the definition then switches to whether the claimant is qualified to do any gainful occupation that they're reasonably educated to do. So that could basically be, can you sit at a desk? Can you do work for 40 hours a week, on a continuous basis? And a lot of the policies will also have an income component. So it's, can you also earn, are you able to earn up to 60% of your pre-disability income? So each policy varies. Not all of them are the same, but typically I see this is how the definitions are on the typical group policy.
Okay, so we'll get into some tips for how to prepare for this change in definition, which, like you said, is commonly found in most group, which are employer-provided policies, and not really found that often in the policies that people buy on their own, which are the individual disability policies. But in terms of these tips we're going to talk about, Rachel, when should a person start the process of preparing for the change in definition from own occupation to any occupation?
I usually tell my clients to prepare for this after 12 months of being approved under the own occupation definition. Because what's going to happen is at the 18-month mark, after they've been on claim for 18 months, the insurance carrier is going to start doing an investigation, which means they're going to request, additional claim forms. They're going to be requesting updated medical records, and then they're going to send all of that information to their peer review doctors to do an evaluation and to determine whether they think that the claimant is now able to do any gainful occupation. So what I tell my clients is you got to prepare your doctors early on in this process, because if your doctor is saying, that you have these restrictions and limitations that are preventing you from being able to be an office manager because you're on your feet a lot, you have to lift heavy, boxes, there's a lot of things that you have to do as an office manager. At the 24-month mark, it's no longer do you have to be on your feet all day long, do you have to travel, whatever occupational duties are required for an office manager no longer matter. So then the doctors have to be documenting in their records in advance that you have, and assuming that somebody has, let's say, a back issue that causes them an inability to sit for long periods. Their doctor has to start documenting this, soon, because it kind of looks a little fishy if all of a sudden at the 24-month mark, the doctor changes his tune when the condition hasn't really changed and starts saying that the client can't sit for long periods of time. So it's very important at the juncture of 12 months to 18 months that the claimant go in and speak to their physician, have conversations about this, and inform them, that they have difficulty sitting for long periods, that they're not going to be able to do a full-time sedentary job, and we have to get the physicians to document this, at that juncture.
So the first tip is to work with your physician to make sure that the documentation is not only supporting the inability to perform your own occupation, but really any occupation. Now, when you define the any occupation definition before, you said that there's an income component, and that is commonly found in there. And usually it's something that pays up to 60% of what the claimant was earning prior to them becoming disabled. So that puts something into perspective for a person to understand, well, what kind of job would pay 60%? If I used to make, $50,000 a year, what's now going to pay me $30,000 a year? What type of job would that be? For the higher wage earners that were making upwards over $90,000, $100,000, it's often that if you had a $100,000 job, there's likely not a $60,000 job that you could do either. And how do you prepare, or what kind of evidence do you present to show that in terms of the different types of jobs, that there aren't jobs available at the $60,000 mark that were similar, or forget they weren't similar, but like a $60,000 job, whatever it is, based upon the education, experience, and training of the claimant?
Right, and that is something that we usually will hire a vocational expert that that will be familiar with and will review the medical records, the job description, the occupational duties, to be able to analyze whether or not the claimant's able to be hired for a certain job, actually be able to handle that job, and actually get paid 60% of their pre-disability wages. And a lot of these jobs only have to exist out there. The claimant doesn't actually have to be hired for the job, because I'll have a lot of questions from my clients who will say, yeah, well, they say that I could be, I could sit down and I could be a clerk, and I could review records, and I could sit at a desk 40 hours a week, but what if I don't actually get this job? And I said, it doesn't matter. They just have to prove that that job is out there. So what we do is we work with the vocational expert and the doctors to make sure all the records are in conjunction with each other, and show that, number one, the client or the claimant cannot perform the job physically because of their disability and their inability to sit for long periods, their inability to focus, maybe they get fatigued and they can't concentrate, and also that these jobs don't exist as far as being able to make this type of salary in the claimant's area where they reside.
Right. The last point you made is good. That's called a labor market analysis that the vocational expert can do as well, to say, well, yeah, you did come up with some random job, but it's not available within 100 miles of where our client lives. So therefore, you can't expect them to do that job, because they're not required to move, and they're certainly not required to drive, over an hour or more to get to work. So they do have to prove, or at least we make the argument, that you can't say, well, we don't care if the job exists or not. Now, you can't just make up jobs and then think that they're available or not available. So, the second tip is you could work with a vocational expert, or at least we usually work with the vocational expert on an appeal, but you should be acting like a vocational expert. And of course, if we're on the file, we're going to advise you as to these are the jobs that they're going to say you can do. These are the duties of those jobs, and we need to make sure that your doctor is clearly documenting that you can't do these particular jobs. The other thing that always comes up in the change of definition is these additional claim forms, these vocational analysis forms. Talk about those that you often see from most of the major disability insurance carriers, and how careful you have to be when filling those out.
Yeah, well, they will send these vocational forms to the claimants around, let's say, the 18-month mark, and they want to know, what your skills are. Do you know how to use a computer? Do you use a laptop? How many hours a day are you sitting at a computer? What type of education you've had. Do you have a business? Are you currently, running a business? Are you trying to open a business? They ask all these types of questions, and depending how the claimant answers them, the insurance carrier can jump to the conclusion that, hey, you already sit on the computer 5 hours a day, 6 hours a day, according to you. So you could sit at a desk, sit at a computer, answer a phone, and work full time, because this is what you're doing anyway. So I tell my clients to be very careful how they fill these out, and obviously we fill them out in conjunction with them, and I review everything before it goes to the carrier to make sure that we're not putting anything in those forms that could get them to not get their claim denied, because that's exactly what the insurance carrier is looking to do. So it's very important to make sure that everything in the form is accurate, it's not exaggerated, and that, you know, we're not claiming that our client can do things that the insurance carrier is then going to interpret as, well, you know, they could go back to work and do these jobs 40 hours a week, you know, on a regular basis, because they've already said that they sit on the computer all day long.
A few other tips, Rachel, of things I know you see a lot with the change of definition is, number one, they're going to want to interview the claimant usually, whether it's in person or on the phone. So I know we do extensive preparations of our clients, advising them as to every single thing they're going to be asked. And when those interviews come up, you should assume as a claimant that they probably put you under video surveillance recently. They've run all of your social media profiles, whether you're on Facebook, Instagram, TikTok, whatever you're doing. Your kids, your husband, your wife, they're going to look to try to get whatever connection they can. They're going to run your credit report if you gave them permission to do that. They're going to look to see every single thing that you're up to and then try to ask you questions to get you to say something inconsistent. And that's all part of that transition from your, you know, own occupation to any occupation. So that's a big thing. The one other final tip, which I think is hugely important, is the fact that, you know, usually they're going to have their in-house doctor reach out to their treating doctors. And that's usually not done in the manner you would think, because 9 out of 10 times your treating doctor doesn't answer the phone because it's just another insurance company calling, or they send a letter and it's just another form from an insurance company, and either the doctor doesn't respond to it, or a physician assistant or a nurse responds to it, and they treat it like, can you function, when they respond to the forms, like in your activities of daily living, and they don't address it so much as in terms of your ability to do a job 8 hours a day, 5 days a week. And that is where we see a lot of denials come up, because the doctor doesn't have a heads up that this form is coming. The doctor doesn't really understand the scope of what's involved when talking to the insurance company doctor, because the doctor has hundreds of patients. So as a claimant, you need to prep your doctor, you need to let him even know, and we often suggest, tell your doctor not to speak to them, tell them to send the questions in writing, and then the doctor can reply in writing, so that there's no he said, she said, no inconsistencies, everything's done in writing. And that's totally legitimate. And when this case goes to distance later on, especially if it's governed by ERISA, it's only a trial on the papers. So the conversation they had, if it's not well documented, it doesn't matter. So you're better off having everything in writing rather than having your doctor have some random conversation, which will likely be misinterpreted by the insurance company for the benefit of the insurance company. So, so these are 5 or 6 different very helpful tips to help avoid a disability denial at the change of definition. And it is one of the most highly scrutinized times. But Rachel, as you know, this analysis can go on at any time regardless of the change in definition. Whether you've been on claim for a year, 5 years, 10 years, we have people call us who've been on claim for 18 years. It's the same analysis, it never ends, but we know it happens without doubt between a change in definition. So that's why we wanted to focus on that. But this advice we're giving, this is consistent at any time throughout the duration of a claim, no matter what. So no matter what stage your claim is at, feel free to call Rachel or call myself. We're available to help you with your claim all over the country. Our clients are located in all of the states, and we regularly communicate with everyone, obviously through the phone, through email, through Zoom, FaceTime type calls. So that's never been an issue. And of course, the disability carriers are all over the country as well, as you know. We invite you to subscribe to our YouTube channel because we're regularly putting out videos that we hope you find helpful. Additionally, if you call us with your claim, we're going to provide you with an initial free consultation, and we're going to let you know right away how we think your claim could be improved, how we could help you with your claim. No matter what the issue is, we're going to answer your questions during that initial consultation. And we encourage you to spend some time searching our website, as we have a lot of helpful information, especially information that is specific about your company. So if you search by your company, you're going to find a lot of reviews about your company, questions and answers that Rachel, myself, and our other lawyers have answered, and lots of lawsuit summaries and cases that we've handled, because we want you to be really knowledgeable, because the more you think like the disability company, the better your chances are to keep your claim from being denied and keep you from being approved, giving you the chance to be approved if your claim hasn't been approved. So We look forward to the opportunity to speak with you should you need us in the future. Thank you.